Afternoon, everybody. It's past noon. Thank you for joining us for our third deep dive into key bills from this past legislative session. The legislative review webinar is one of, next slide, Patty. It's our third one. And we appreciate you. If you're joining for the first time, welcome. You're joining for the third time, or the second time. Thank you for coming back and listening to the different various topics because we've had a very busy legislative a year, and we hope that the advice and the feedback we've provided so far has been helpful. Today's deep dive is going to cover a series of bills. It's going to be it is worth one law CM. Um, you'll be able to access the slides on the at a download, and everything is hyperlinked in. So if you need to go back and get the prior session or to register for your CM unit for this, everything should be hopefully very easy to do. So we have a great panel for you today that's going to cover everything from SB 492 and Mitigation Banks all the way down to beaches. We'll have a Q&A session at the end. And also, before we do that, we're going to see what we expect from the 2026 session and committee week preview. With me here today, I have a wonderful slate of panelists. First is Barry Wilcox. Barry is a certified planner and Florida certified public manager with more than 20 years of experience in the public and private sector in Florida. For nearly a decade, Barry held key managerial roles in Leon County, including as the Director of Development Support and Environmental Management, where he oversaw a multi-million-dollar budget and led a team of over 70 professionals working in the fields of urban planning, environmental planning design, construction permitting inspection, and code enforcement. We also have with today Aaron Tilton. Aaron was Stearns Weaver. I want to mention Barrett was Stearns Weaver. Aaron represents clients before courts, state agencies, and elected bodies on land use and real estate development issues. Her practice focuses on disputes involving private property rights, complex real estate transactions, comprehensive planning, zoning, development of regional impact, and other planning and large-scale development. She is skilled in developing and implementing litigation strategy as it relates to obtaining, challenging, and defending development approvals. We have with us also today Michael Wood from Cobb Cole, Michael partner at Cobb Cole, and his focuses his practice on all manners of residential and commercial property development, with a focus on the entitlement process and public-private partnerships related to the same. He supervises the application process, addresses neighborhood concerns, and represents his client at public hearings before multiple local governments. He graduated from the University of Florida in 2000 with a BA in political science. In 2004, he received a Juris Doctorate cum laude from the University of Florida Levin College of Law. Our fourth speaker today is Will Dunaway, who's a shareholder at Clark Partington. Will practiced primarily around environmental and land use law. He has experience in local, state, and federal land use planning and the associated environmental permitting. Will has negotiated environmental matters at the federal, state, and local governmental level. He represents clients before local government commissions, councils, and boards on land use and environmental issues. Will's litigation training began in the military justice system, where he served as a trial and defense counsel and ultimately a military judge. Last but not least, it's Anna Grace DiPaola. Anna Grace is a policy advisor who joined the firm after serving as the policy analyst for the Florida House Transportation and Modal Subcommittee. Previously, she worked at the Florida Chamber of Commerce, where she was the policy director for talent, education, and infrastructure. As a policy director, Anna Grace formulated policy and legislative strategy for early learning, K-12 education, higher education, workforce, transportation, water, and energy issues on behalf of the Florida business community. There, she was named a Florida Politics Rising Star for the class of 2022. Anna Grace is a graduate of Florida State University and their honors college, which she earned undergrad degrees in political science and history. Next, please. All right, I'll go further. For those that don't know me, hi, my name is Eddie Ning. I should introduce myself very early on. I am your APA Florida President elect and head of your Legislative Policy Committee. So, where are we now with our plans for this? Now that we're entering legislative committee weeks. Well, APA Florida is very focused on SB 180. We've heard a lot from you, our planners throughout the state, and your concerns with getting through. And certainly, I've encountered some of the same issues that you have as well. So, where are we now with SB 180 from APA Florida's standpoint? We're monitoring the current lawsuit that's been filed. We're reviewing HB 217, and we're trying to gather and provide feedback to communities, to and from the communities. What you see here is the QR code, and we need you to tell us your story, impacts, and examples. We're also partnering up with folks at UCF, and so please be on the lookout for UCF survey that will come out on the emails and the listserv. It's really important that as we work with the legislature behind the scenes that we're trying to do right now and giving them stories, that these are all reflected because they will influence how they might approach what we call glitch bills, right? How we know there are changes that need to be done to SB 180. By having your stories about the impact on planning, how it impacts your local communities, how it blocks recovery in some cases, from what I've heard. These are all very important because it's not just us, individuals are looking at. If I have your story, then if a lot of your consultants had your story, we can create a more targeted approach to saying, hey, this is what should change based on a professional review. So please be on the lookout for those, and please utilize the QR link to go forth for it. We also know that it will be on top of the October 31 issue. So again, be on the lookout. And with that, we're going to start diving in with Mitigation Banks, and I'm going to turn it over to Erin and Barry for the first bit.
Thank you, Eddie. Appreciate the introduction. And let's kick it off with Senate Bill 492, which deals with mitigation banks. Let's start with, what does this bill do? Senate Bill 492, in summary, adopts two major changes to Section 373-4136 of the Florida statutes, which, as you know, governs the establishment and operation of mitigation banks in Florida. The first major change is to subsection 5, which deals specifically with schedules for credit release. So in place of the current practice of the mitigation bank permit applicant negotiating a credit release schedule with either DEP or the water management districts, depending on the case, SB 492 prescribes a schedule for credit release that both DEP and the water management districts are required to adhere to for any new mitigation banks beginning July 1st of 2025. That prescribed credit release schedule includes a 30% credit release for recording conservation easements and establishing the bank's financial assurances. There is then another 30% credit release for completion of initial construction activities, 20% release for meeting interim performance criteria, and the final 20% for meeting those final success criteria. Importantly, permit applicants can still propose an alternative credit release schedule, which the agencies are required to consider. And also, existing mitigation banks can request a permit modification to conform their credit release schedule to this new statutory release schedule. The agencies are required to approve that modification if the bank has not yet released credits for the completion of construction activities. The second major change is to subsection 6, which deals with mitigation service areas. And this change allows mitigation credits to be used outside of their established service area under certain circumstances, specifically where DEP or the water management district, depending on the case, determines that there is an insufficient number or type of credits available from banks within the service area where the proposed impact occurs. That permit applicant is entitled to a one-time use of credits from a bank outside the service area to offset those impacts. Credits that are used within the same regional watershed as the proposed impact have no multiplier factored in, but credits from an adjacent regional watershed add a 1.2 multiplier. So essentially, you're using more credits to mitigate the same impact if you are in an adjacent regional watershed rather than in the same watershed as the impact. And then there are additional multipliers of 0.25 for each additional regional watershed boundary that's crossed, and an additional 0.5 multiplier where out-of-kind credits are used. There is a process for utilizing out-of-service area or out-of-kind mitigation credits. It requires the applicant to submit a request for that out-of-service area or out-of-kind mitigation. And within 7 days of that applicant's request, DEP or the water management districts are required to contact all mitigation banks within the service area of the proposed impact and request an accounting of the available credits. The banks are then given 15 days to respond to the agencies. And at that point, DEP or the water management district has to notify the applicant as to its determination of credit availability within a 15-day period. The applicant can rely on that determination of credit availability or non-availability for a period of 6 months only, and only as to the pending permit application. And the last change I'll mention, this one is very minor, is that the statute now requires all banks to annually report their credit availability by both number and type of credits. And the agencies are required to collect that information and report it to the legislature by October 1st of every year. So a couple of legal considerations. First, we want to make sure we understand that the statute expressly limits the time that a permit applicant can rely on a credit availability determination. Importantly, that express limitation precludes reliance for extensions, for renewals, or for other permits aside from the one for which the applicant submits that eligibility determination. It's very important that applicants monitor that timeline, or they can lose the ability to mitigate out of service area. Second, in preparing whether it's a credit reservation contract or a credit purchase agreement, those really need to be revised to reflect these statutory changes, including the new release schedules and also the bank's obligation to respond to those agency accountings. And it's also important to note that the failure of a mitigation bank to respond to an agency accounting request creates a presumption that no credits are available at that bank. And last, the annual accountings and report to the legislature that I mentioned will become public. So that is an important thing to note because the industry can really leverage those reports to verify market availability, plan mitigation strategies and timelines, and also kind of it creates a mechanism for transparency.
So taking over from Aaron here, what does this mean for us as planners? Well, while we could probably debate the concept of wetland mitigation banking, that'd be a whole session in and of itself for a few hours. What we probably wouldn't debate is the need for standardized methodologies for the implementation of any sort of credit program or mitigation program. This is pretty similar to what we saw, and some of you may be around long enough like myself to remember the early days of transportation school concurrency when we were kind of flying by the seat of our pants. We quickly realized that we needed some standardized methodology there to allow us to track credits, to determine how credits were applied. Annual reporting is key to that. And so I included on this slide for everybody a few key takeaways to that. If you're putting together any sort of program locally, predictability obviously is key. Here, what we had with mitigation banks was a real lack of predictability, especially at the forefront when you're trying to do your pro forma for a project and determine, well, are there credits available? Are they within our basin? Am I going to find out that there are no credits available? Is that going to be a showstopper for me? Secondly, flexibility. Well, you now can go outside outside your watershed, and again, that's another thing to debate, but it does provide some flexibility to the program. You're going to pay a little bit more going outside the watershed, but at least it isn't a showstopper for your project. And finally, transparency, that all important annual reporting that we remember from so many of our programs is now a critical piece of the mitigation banking program. I think that's it for me.
Thank you, Aaron and Barry. Next up, we have Mike, who is going to cover House Bill 481 anchoring, followed by Senate Bill 384 annexation. And over to you, Mike.
Thanks very much, Eddie, and I appreciate the opportunity to be here today. Um, I've loaded up the slides for the presentation on HB 481 with a good bit of background information regarding all manners of mooring and anchoring provisions for technical comments. And it's helpful if you're reviewing these slides at a later time to kind of help digest the terminology. The actual edits themselves are pretty straightforward. And in fact, we're going to address 3 edits to the statute, only one of which is generally applicable, and it's the smallest, most minor edit. There's another one that only impacts Miami-Dade County, and then the bigger scope, but still only impacts the 5 counties that have populations of greater than 1.5 million. So we go to the next slide real quick here. To me, when we're dealing with any of these legislations, I think authority is key. Knowing where the authority for the regulation or the structure for the regulation comes from, I think it helps to understand loopholes or the illogical regulations that you can't really make sense of. So for our purposes today, I think the important takeaway for you to kind of understand or to be reminded of is, one, under the Florida State Constitution, there is a constitutional right protected by the Constitution for hunting and fishing. Obviously, the fishing is going to come into play since we're talking about boats, mooring, and anchoring. Within that authority, the Florida Fish and Wildlife Conservation Commission has the authority for vessel safety. And that's predominantly where you're going to see this regulations come through. And the agency you'll be probably interacting with when it comes to the local jurisdiction, trying to make all these pieces connect together. And I think it's also important to recognize, the Board of Trustees of the Internal Improvement Trust Fund, they still have their authority for the sovereign submerged lands, but when it comes to boating regulation or more accurately to anchoring rules, they haven't really exercised their authority. This is predominantly coming through Fish and Wildlife. Next slide, if you could, please. Okay, so on this slide, a series of terms, again, not necessarily being edited by the text of the bill itself, but just for a frame of reference, the distinction between anchoring and mooring, floating structures, liveaboard vessels. You're probably familiar with that if you're in a waterfront community and have dealt with this before. I think the important term on this page, moving forward with the actual edit, is the definition of the mooring fields. Statutory authority under Chapter 373 allows the local jurisdictions to establish these mooring fields, and quite simply, this is boat parking lots on the water. This is a permanent structure in the ground to which you will tether to. They're limited in size. You can have no more than 100 vessels, and this is authority for the local jurisdiction to establish them. And the important element here is that there also has to be land-based services servicing the people that are on those boats. You're thinking about washer, dryer, shower facilities, upland fueling opportunities, and then obviously some prohibitions of uses on those boats in the water. Can't allow boat repair, can't allow for painting, scraping of hull. Common sense approach kind of comes with that. We can go to the next slide, please. So our first other term that we're going to kind of talk about is anchoring limitation areas. And then anchoring is defined earlier in the slides is just as you would think on a boat with an anchor tethered to the boat that you then throw into the water. The anchoring limitation areas, they're statutorily created areas, predominantly just Miami-Dade and Broward. But this is where boat traffic and volume of that boat traffic, proximity to residential docks and ins and outs of getting into the waterway there, and really narrow waterways make it unsafe to anchor where you would otherwise maybe permitted by right, but specifically at night. And these areas listed here were on the books prior to HB 481, and we'll talk a little bit about what got added to it down in the Miami-Dade area. So the next slide, please. So the anchoring limitation areas, what are the limits? Basically a vessel half hour after sunset, half hour before sunrise, so nighttime, can't anchor in these areas. Basically think of a health, safety, welfare situation. There are exceptions, obviously. Some are pretty readily apparent. If you're having a mechanical failure with unreasonable risk of harm, then you can anchor in those areas. Or if inclement, imminent weather conditions are coming in with it, again, with the unreasonable risk of harm. That is the standard that applies. Then you can anchor in there. And then there's obviously a carve out if your local jurisdiction or area is doing a parade or regatta and things of that nature. It doesn't apply to government boats, so law enforcement or your municipal boats. Dredging operations are explicitly excluded. And coming back to those constitutional authorities, actively engaged commercial fishing or active recreational fishing doesn't apply. And that's kind of the interesting thing there is that, you know, you may be on your boat, and if you're taking a nap, you're going to be in violation at night, but if you have an active line in the water, then you're going to be in the clear, which I'm sure creates a whole lot of issues for enforcement. And then the local jurisdictions also have the authority to establish anchoring limitation areas on their own, subject to certain conditions, and those are in place there. Again, not new from the bill, but I want you to have that background information. Next slide, if you can, please. Okay, and then this slide just kind of lays out the very basics, again, not really being changed by this bill, except for one thing on the boat, where a boat can and cannot anchor. This is probably navigation 101 for these guys to get their licenses, but basically don't tie or don't anchor in a channel, don't create a navigational hazard. And then there are some statutory defined spacing issues and proximity limitations to where you can anchor off. And then the other provision there, again, not being changed by the terms of this bill, is the general authority with the local government of how they can enact their ordinances, you know, the distinction between floating structures or live aboard vessels. And if we need to, we can come back to that for questioning. But this terminology in of itself wasn't amended by the bill. So we can go to the next slide, please. So here we come to the relevant first section of HB 481. And it's one of those we're dealing with exceptions to the exceptions. And when we get to the next slide, I'll kind of draw that out for you. But in brief, this is the amendment that only deals with jurisdictions that have populations that are greater than 1.5 million. So as of right now, we're dealing with Broward, Hillsborough, Miami-Dade, Orange, and Palm Beach counties, and they can now have the authority to regulate. And what we're talking about here is adding a new extension of authority for those jurisdictions into an area where they otherwise would not have any say or authority over an anchored vessel. Specifically, we're talking about vessels that are anchored for more than 1 hour during the night. It's that 1/2 hour before and after sunset that's kind of defining the night terms. And for more than 30 days in any 6-month period. And the legislation doesn't really provide any guidance as far as it have to be 30 days in a row, just as 30 days in that 6-month period. If they are within, or if they are anchored in that area, does not apply to marine construction. It doesn't apply if you're actually in a marked mooring field. And if you go to the next slide, it kind of shows you the you know, when you're trying to read the language in the statute, exception for the exception for the exception, and you can get lost trying to figure out how to apply it. But I think if you go to the next slide after that, in the nutshell here, and this is kind of like the bottom provision on that next slide, yeah, right here. If you view the mooring fields where there's, you know, the boat parking lots the jurisdictions can create as an extension of the authority of the local jurisdiction into the waters, like a municipal embassy into sovereign submerged land, so to speak. This provision with the HB 481 really extends the authority of that jurisdiction outside the walls of the embassy when those specific conditions meet. And again, it's just in big jurisdictions. You know, presumably this is in response to enforcement challenges for, you know, long-term folks anchoring outside the jurisdiction and giving limited authority to limited jurisdictions to address it, certainly not granting a full authority across the board and allowing, you know, Water Management District, the Fish and Wildlife Commission to retain the majority of their authority there. If we go to the next slide, we'll go to the second part of HB 481. And again, this one is really just limited to Miami-Dade County. We had previously talked about that anchoring limitation areas. Again, this is at nighttime and where a boat can safely anchor. Because of the dense populations down, right now the statute only applies in Broward and Miami-Dade. And as you can see on this slide, the areas that are underlined were added with this bill to also include these areas as anchoring limitation areas. Pretty straightforward on that. Next slide. And then the final element, which is the only one that's really globally applicable, gets into the limitations of where a boater can and cannot anchor. And here, if you are anchoring off of an established marked public mooring field, previously that boater had to stay at least 100 feet away. Now the statutory provision extends that out to 300 feet. But the caveat that was there before is still there, that local government can reduce that if they're so willing to do so. So those are really kind of straightforward, very, area specific kind of provisions. So not a whole lot from a practice standpoint to kind of make you alert to, other than if you're in Miami-Dade or in one of those 5 jurisdictions with the extended enforcement. Moving on to SB 384, this one is really straightforward. If your city is annexing state-owned lands, you now have to notify, and I quote in there, each member of the legislative delegation of the county in which the land is located. You can do this by email, but it has to go to each member. You can't just send it to a bulk delegation, or it could be in writing, and this has to go out when you advertise for the first public hearing. Generally not a big deal, generally not really a huge ask, and probably comes out of a situation where a legislator felt like they were out of the pocket on something and caught unaware. If you go to the next slide though, from a practice standpoint, the only thing that kind of turns my spider senses on is this is something that can be very easily overlooked. Most jurisdictions, if you're not doing a lot of annexation, this isn't really going to come up. If you don't have a whole lot of public lands in your jurisdiction, not going to come up. And even if you kind of rely and make your internal checklists, that are in your Muni Code ordinances based on the statute, this provision comes in the statute, and I lay it out there on the slides, that is more about notice than it is about the checklist of what has to accomplish. So again, just something really easy to overlook. And I just, I fear my heart for that baby planner that is doing their first annexation and just doesn't know to look for this. So what do you do to kind of protect yourself? First and foremost, I think you amend your application forms to either provide for a field to fill in or to check the box to say whether or not there is state-owned land that will be subject to this particular annexation. The other side, I kind of say this tongue-in-cheek, but it's within the letter and the keeping of the law. You can just go ahead and notify your legislative delegation of all your annexations, regardless of state ownership, and you will have checked the box and you build that into your regular process. Again, since it's just an email or a letter, it's not asking all that much from your local jurisdiction to do. The big reason why this is important is because this is a notice provision. And as you all are probably very well aware, we drill it into all of our attorneys and when we deal with our planners, failure of notice, your DOA, it's void ab initio. And you'd really hate to have an annexation and then the likely zoning and land use amendment that goes along with it to have to go back to the starting line just because you didn't copy the good folks in Tallahassee that are trying to monitor and make sure you are executing your home rule power with the way in which they intended you to do so. That is a little tongue-in-cheek there, but you definitely want to make sure that this small oversight could really scuttle your annexation efforts. And with that, those are our 2 bills that I was dealing with, and I thank you for your time.
All right. Thank you, Michael. Next up, we have Senate Bill 700, which deals with rural land and agriculture, and we're going to bring Aaron and Barry back for those. Take it away.
Yeah, thank you, Eddie. And we've at least internally joked that there should be some sort of intermission, to this program during the update on Senate Bill 700. Strap in; it's a long one, and with that, let's kick it off. So SB 700 makes a very lengthy list of changes to laws related to the Florida Department of Agriculture and Consumer Services and related entities. It starts off by creating a new subsection 5 to section 163-3162 of the Florida statutes. And this new section is titled Housing for Legally Verified Agricultural Workers. Legally verified agricultural worker is defined in the bill as a person who is lawfully present in the United States, meets the definition of eligible worker under federal law, has been verified through the process provided in 448.095 sub 2, and is authorized to work at the time of employment, is seasonally or annually employed in bona fide agricultural production, remains lawfully present and authorized to work throughout the duration of that employment, and is not an unauthorized alien as defined by statute. So the statute goes on to prohibit government from adopting or enforcing regulations that inhibit the construction of housing for legally verified agricultural workers on lands classified as agricultural and operated as a bona fide farm. It goes on to provide certain minimum criteria for this housing, including dwelling separation, climate-controlled square footage caps, setbacks, buffer and screening options, but does include grandfathering provisions for structures that existed prior to July 1st of 2024. It requires property owners to maintain records of all approved permits for migrant labor camps and housing for at least 3 years, and must also make those records available for inspection upon government request. The law requires FDACs to complete routine inspections of that housing, review and investigate complaints, and enforce any violations. And finally, FDACs must also submit any data and information that is collected to the State Board of Immigration Enforcement on a quarterly basis. Next, SB 700 creates a new subsection 19 to section 253.0341 of the Florida statutes, which deals with surplus of state-owned lands. This new section authorizes FDACs in consultation with DEP to surplus lands acquired from an electric utility under a new process that's outlined in section 366.20, which we'll get there in a minute, if FDACs determines that the lands are suitable for bona fide agricultural production. If the lands are surplused, FDACs must retain a rural lands protection easement over the property, and all proceeds are required to be deposited into the department's incidental trust fund. Lands that are designated as state forest, state park, or a wildlife management area are not eligible to be surplused. And importantly, this subsection, and this subsection only, is retroactive to January 1st of 2009. Next, SB 700 tackles unmanned aircraft systems. It adds 2 new subsections to section 330.41 of the Florida statutes, which is the Unmanned Aircraft Systems Act. These 2 new subsections essentially criminalize unauthorized or disruptive drone use over agricultural lands and unauthorized drone use with the intent to harass over private property, state wildlife management lands, and sport shooting and training ranges. The first offense under the statute is a second-degree misdemeanor, with each subsequent violation rising to the level of a first-degree misdemeanor. Importantly, again, if the violation over private property, a state wildlife management land, or sport shooting and training range includes video recording, the first offense is a first-degree misdemeanor, and each subsequent violation rises to the level of a third-degree felony. Circling back to electric utility-owned property, so the next portion of SB 700 creates a new section 366.20 of the Florida statutes, which deals with the sale and management of lands owned by electric utilities. So this new statutory provision requires that lands that are owned or acquired by an electric utility on or after January 1st of 2009 that have been classified as agriculture at any time during the 5 years preceding the acquisition by the electric utility. Those lands must be offered to FDACs for acquisition prior to any sale or transfer to a private entity. So the statute requires that the electric utility provide FDACs with a written intent to sell at least 30 days before offering the land for sale to a private entity. Upon receipt of that intent to sell, FDACs has 30 days to issue a written intent to purchase. If FDACs either declines to purchase or doesn't respond to the written intent to sell, then the electric utility is released from the requirements of the statute and can proceed with the sale of property to a private entity. Recall again that pursuant to the new section 253.0341 sub 19 that we just discussed, FDACs can then surplus lands it acquires from an electric utility if it determines that that land is suitable for bona fide agriculture. So these two provisions really need to be read together. Moving on, SB 700 then makes revisions to section 366.94 of the Florida statutes, which governs electrical vehicle charging stations. It revises the definition of electric vehicle charging station to mean the area in the immediate vicinity of electric vehicle supply equipment, and specifically includes the electric vehicle supply equipment, supporting equipment, and associated parking spaces. So we've really broadened the definition of EV charging station with this bill. It goes on to strengthen the existing state preemption of EV charging station regulation by authorizing FDACs to adopt rules both to protect the public health, safety, and welfare, and also to establish standards for placement, design, installation, maintenance, and operation of EV charging stations. Local governments shall, under this new law, shall issue permits for EV charging stations based solely on FDAC's established standards. And FDACs is also allowed to prescribe by rule the time period for local governments to approve or deny a permit application.
Aaron, I'm going to jump in there just to give you a little bit of a break. I know you've still got a lot to go. So omnibus bills like SB 700, which is 111 pages long and covers literally everything under the sun, is what we refer to in Florida as an agency package, because theoretically, all of these matters apply to FDACs or under the purview of FDACs. This first one you see here about the sale and management of lands owned by electric utilities, which came in addition to the previous slide, which addressed more surplusing of lands by electric utilities. Just a heads up, SB 290, which is FDAC's agency package for this coming year, was filed on Friday and contains additional language in there regarding surplusing of local government lands. So that's one you're going to want to really track because it does affect how you surplus local government lands and right of first refusal to the state for agricultural purposes and so on and so forth. It's a bit confusing, to be perfectly honest, and clearly was tailored towards a very specific situation somewhere. EV charging gets real easy here, folks. If you're still out there as a local government planner trying to regulate EV charging, just don't. This, on top of previous legislation, makes it really clear that EV charging is something that the state wants to regulate. And while you can still issue permits for that, like Aaron pointed out, all has to be through standards established by the state for EV charging stations. Parking spaces, pretty much every bit of infrastructure goes with EV charging. So I know in Leon County, we had adopted an EV charging regulation several years ago now, and already we're probably going to be undoing that. So that's just my 2 cents on that portion of it. Give Aaron a little bit of a break there from the rest of it. So here you go.
Thanks. And just kind of dovetailing with what Barry said, the kind of final revision in this bill related to EV charging stations requires registration with the state before those stations can be placed into service, and also gives, so FDACs not only now has the authority to regulate placement, establishment, kind of the traditional standards that a local government would regulate, but also now has the authority to inspect, to conduct investigations, to enforce its own rules, and to impose penalties for violations as it relates to EV charging stations and EV charging station regulation. And this is where SB 700 goes a little bit off the rails. So as Barry mentioned, it's sort of an omnibus catch-all bill for everything FDAX, but there's so much in this bill that we wanted to kind of try to give you a little bit of a flavor for each, and then be available to answer questions as needed. Mosquito control programs, probably one we haven't heard from in a minute. The bill makes multiple revisions to mosquito control programs, both for budgeting, reporting, all of those types of requirements. And then the very next section of the bill is allowing FDAX to establish an enrollment by rule process that small agricultural pollutant sources may use in lieu of adopted BMPs where certain parcel requirements are met. The bill then goes on to prohibit the use of any additive to public drinking water supply that is not for explicit purpose of improving water quality. In other words, goodbye fluoride. It allows FDAX to provide pest control certificate examinations in person and remotely through third-party providers, and goes on to require FDAX to publish a registry of charitable organizations that do not solicit or accept directly or indirectly contributions, funding, support, or services from, and whose messaging and content are not directly or indirectly produced or influenced by a foreign source of concern. The bill goes on to prohibit the transport, import, sale, etc. of spores or mycelium capable of producing mushrooms or other material which will contain a controlled substance. It grants FDAX rulemaking authority to enforce FDA's standard of identity for meat, poultry, and poultry products, and prohibits in the state of Florida the sale of any plant-based products that are mislabeled as meat, poultry, or poultry products. It creates an annual petroleum registration program for owners and operators of petroleum transport vehicles, creates a Florida Retail Fuel Transfer Switch Modernization Grant Program, creates the Florida Aquaculture Foundation, creates the Silviculture Emergency Recovery Program, creates the Beef Marketing Program, and finally creates the Florida Farmer Financial Protection Act. And the last thing we'll mention with regard to this bill is that it prohibits local governments from adopting regulations that limit the activities of public educational facilities for agricultural education, which includes the storage of animals and equipment. There's also some stuff in here about concealed carry. We won't get into that today. It's probably an entirely separate presentation, but suffice it to say, this one is a dense read.
Yeah, I told Aaron I'd do this. As I was going through the bill, we were kind of mulling over all the things that were in there. Legal farm worker housing, drone strikes, fluoride treatments, beef marketing, fake milk, North Korean charitable contributions, boll weevil, minstrel shows, fuel theft, mail theft, and magic mushrooms. So that's your summary of SB 700. Now, how does it affect us as planners? Again, another preemption there, and it comes in the form of agricultural worker housing. If you're a local planner who's trying to regulate farm worker housing, again, just don't. This is another one of those preemptions. I know all of you are very busy doing a whole lot of other stuff. So if the state feels that they need to preempt us on this one, I'd say we just go ahead and let them do that. Strengthens preemption of EV charging. So again, another preemption. I think we covered that one earlier. Preemption on public educational facilities for agricultural education. I don't know that that was a huge problem, but some of you may have encountered it. And finally, we get back to the electric utilities. Again, that's the one I really want to highlight because, like I said, there's an update to that section of the bill in this year's agency package. And again, I'll give you the number of that. That is, apologize, SB 290, and that was filed on Friday. So you can find that on the Senate's website. There's another slide to this one.
So let's talk about a slightly shorter bill. House Bill 211, which covers farm products. House B 211 amends the definition of farm product that is currently in section 163, 3162 of Florida statutes. Speaking about preemption here again, that statute, as you may know, preempts government from regulating activities of a bona fide farm operation if the activity is already regulated either through implemented best management practices, interim measures, or administrative regulations of, I think it's DEP, FDACS, or Water Management District, or if it's federally regulated. As amended, the definition of farm product now includes plant and plant products, regardless of whether such plants and plant products are edible or non-edible, or any animal useful to humans, and includes but is not limited to any product derived therefrom. The bill also clarifies that collection, storage, processing, and distribution of a farm product are activities of a bona fide farm operation that the government may not prohibit, restrict, regulate, or otherwise limit as long as the land is classified as agricultural and the activity is either regulated, again, through BMPs, interim measures, state rules, or expressly regulated federally.
So what does all that mean? Once again, we've got some vaguely coded language there that basically comes down to this. If you're a local government or regional government, that's you're prohibited from regulating any bona fide farm operation. Most of us knew that already, but I think there were a few gray areas, and they've seemingly shored most of those up. Most importantly, and what this bill seems to get to, is this now includes on-site biomass processing facilities. So if someone wants to liquefy cow manure on their site, there's very little you can do about it, despite the sheer number of phone calls that I'm sure you'll be receiving from surrounding neighbors. Again, those get forwarded on to FDACS because this is FDACS's area of concern now. If there's any more on there, yeah, that's pretty much it. Thanks, Aaron.
Yeah. Thank you, Aaron and Barry. Next up, we have House Bill 622 covering beaches and other aspects. With that, we have Will. Will, take it away.
Thank you, Eddie. So House Bill 1622 actually repeals Chapter 163.035 Florida statute. This, unless you were in Walton County, Indian River County, or one little municipality, Reddington Beach, you probably didn't pay much attention to it. But in Walton County in Northwest Florida, it was a huge deal for the last 4 years and resulted in a massive litigation with their private citizens. Essentially, what this state did was just, make the noise go away. And they just repealed the whole thing. 163.035 had put in place a procedural process by which the establishment of customary use could be done by a local government, county, or municipality. And as I indicated, very few actually followed through with that, but Walton County did, and it turned into a big mess. Essentially, what the repeal does is it puts Florida back in the same status that it's been in for its entire existence, and we just go back to the law of customary use as established by both common law and the Supreme Court in the case of Tonoroma back in 1973. So if in fact a local municipality wanted to weigh into this issue, it could, but I suggest that before you did, you call your brethren in Walton County to see if that would be advisable. So the next slide gives us real meat of Section 2. So Section 1 is the repeal of 163.035. Section 2 is in fact targeted, as we heard earlier, with regards to the anchoring jurisdiction. This is targeted, and we see that it applies only to certain counties that are adjacent to the Gulf, that have at least 3 municipalities, an estimated population of less than $275,000. If I've done the math correctly, this should only apply to Santa Rosa County, Okaloosa County, Walton County, and Bay County in the Panhandle, and then it technically would apply to Levy and Citrus, although they're mostly their shorelines are mostly marsh, and so I don't think it's going to have that great an impact. But really, it was done for Walton County. They're the ones that lobbied for it. And what Section 2 does is it provides for a bit of a streamlined establishment of an erosion control line. As you probably are familiar, if you're on the coastal county, an erosion control line, if you're going to do beach renourishment, you establish an erosion control line at the existing mean high water line. Then the erosion control line becomes the new boundary, southern boundary, of course, between public and private. And then any beach nourishment that creates beach seaward of the erosion control line is, of course, in the jurisdiction of the state. And this is what happened. If you track the history of what was going on in Walton County, they tried to establish an erosion control line. The private property owners blocked it, essentially because they wouldn't sign the required Corps of Engineer easement, which was a 50-year maintenance easement. And so without the establishment of erosion control line, they couldn't do the beach nourishment, therefore couldn't establish public beaches seaward of the mean high water line, or seaward of the erosion control line. So this section creates a kind of streamlined way of handling that and moving forward. So next slide. So, really, if you're a planner in these limited jurisdictions, Santa Rosa, Okaloosa, Walton, obviously, and Bay, then you've got some streamlined way for the Florida Department of Environmental Protection to establish the erosion control line. There's no notice proceedings. It goes in it should go in very quickly. In fact, the Section 2 tells the state to put that in place, and it makes the legislative declarations that the state does not intend to extend its ownership claims beyond that what it already owns. That is, again, the concept as it was established by the Supreme Court in the Save Our Beaches case establishes that the establishment of erosion control line is not a judicial taking, because, again, the erosion control line is established at the then existing mean high water line, and the mean high water line, of course, is already, our land seaward of the mean high water line is already under state jurisdiction. So just because it used to be underwater and then after nourishment, it would now be dry sand, it's still state sovereign and state jurisdiction. Therefore, it's public beaches, essentially, is how that process works. So again, if you're a planner in the area, if you're working for DEP, understand that you don't have the notice requirements for the establishment of the erosion control line in these critically eroded areas for these limited identified counties. Again, counties that have 3 municipalities and less than 275 people, essentially Santa Rosa, Okaloosa, Walton, and Bay counties in the Panhandle. And then for local county and local planners in other jurisdictions, now that you don't have 163.035 as a procedural, it is possible to do what Walton County did, establish a local jurisdiction, establishing that certain beaches are open to the public via customary use, but do be aware that that would then just lead the private property owners to challenge that and to take it into court, because only a judicial determination can effectively establish customary use in the state of Florida per the Supreme Court. So before you did that, call your planners and your contacts in the Panhandle to see if that's actually a really good deal. And that's all I have on this. Thank you.
All right, thank you, Will. Reminder, folks, please submit your, you have questions, you can submit at any time. We're reading to the end. I know folks have also been texting me, so I have a slew of questions already. Next up, though, we have from our legislative consultant for APA Florida, Met Hudson and Dalton, Anna Grace DiPaolo, who will go over what we know so far now that we're in week 3 of the interim committee weeks. All right, take it away, Anna Grace.
Thank you, Eddie. My presentation is a little less in-depth than what you all have heard so far. It's been a very interesting hour-long presentation so far. I feel like I've learned a lot about each bill, so thank you to everyone. I'm here to talk about the 2026 legislative session and what we see coming ahead. As Eddie noted, the legislature, they are here, they're underway. We are going into next week, week 3 of committee weeks. This year it is an early legislative session, meaning that they will run January to March because it is an election year, which means all the committee weeks will fall in these fall months. So there's 2 in October that have been completed, 2 in November, and 2 in December. I will say it's been a pretty slow committee week process. They've received some presentations. There's a little bit of talk about bills. So I think the speed of things will begin to pick up as we get closer to the start of session. Patty, next slide. I like to point out that there's a lot of deadlines. Everyone in Tallahassee is worried about the deadlines that quickly approach before you know it. Coming up on November 21st is the bill drafting deadline in the House, which means that all legislation, you need to find your bill sponsor, be working on your sponsor, because the draft of that bill needs to get up into drafting. There's also the deadline for appropriations projects. The Senate is a little bit different. They do not have the same drafting deadlines, whereas the House deadline for a bill to be filed is the Friday before session starts. So that's this year, that's January 9th. The Senate deadline is noon on the first day of session, which is January 13th. So it seems like those dates are really far away, but with legislators only here 2 more weeks before that first drafting deadline, there's a lot of talk about legislation that will be filed. I will note legislation is slow to be filed right now. Drafting is very overwhelmed with how many bills they have, we've heard, but as of today, there's 295 bills that have been filed out of what we expect to be approximately 2,000 bills. So those of you who followed this process closely last year, I'm sure you saw there were hundreds of bills that were filed in those last 2 weeks leading up to session. And I'm pretty sure that this session will look a lot like that as well. Patty, next slide. So there is no crystal ball for what the 2026 legislative session will look like. No crystal ball, I think, ever for what session will look like. And as much as we can predict the bills that'll come out or what we think the priorities are, that all seems to change as session goes. And sometimes it's through amendments or it's a late proposed committee bill, but we can kind of predict what we think we might see. And a lot of that this year in the House side and the Senate side is unfinished business that they didn't get to last year. And so as you'll see on this list, the biggest thing we know that they'll be talking about, because we hear it in press conferences today, we hear it in the governor's press conferences traveling the state, and that'll be property tax reform. I'll talk a little bit about that on the next slide. Rural Renaissance is the Senate president's priority from last year that did not get across the finish line, as is medical negligence on the House side. That was a House priority that got all the way up to the governor's office and it was vetoed. That bill this year is already on the fast track. It's been heard once in the House and it'll be heard next week in the Senate, which shows that it's a priority because it's very rare that bills are heard that early in committee week. The K through 12 education funding revision is something that is big in the education world this year, looking at where the scholarship vouchers money is going and how students are counted in charter schools, private schools, and in public schools. Congressional redistricting, the House has made a select committee on congressional redistricting. We know the governor is very interested in redrawing those lines. We're seeing more states start that process. North Carolina did it last week. Virginia says they're initiating it. Texas and California have already done that. So it's something to watch in Florida. And then open carry, we're not going to get into that today. That's another issue that'll probably come up. And then Doge. All of you are very familiar with Doge. Everyone's had this summer of Doge at the local government level, and we do expect the results of those studies and the results of those audits to tailor what we see in the budget this year and also in some of the bills that are filed in the agency bills. Next slide, Patty. Out of the 200, well, now it's 95 bills, there are just a few bills of interest that I will say we are already watching on behalf of APA Florida. Those are SB 48, that's the housing bill, the ADU bill by Senator Gates. This was filed last year. It got all the way through on the Senate floor, and then it did not end up passing. The House and Senate could not agree. This year, the bill is filed in its final form, and it'll be heard next week in a committee week. It's a slow committee week, so they're hearing the bill that they can. It'll be heard next week on the Senate side. Transportation concurrency is another repeat bill filed in its same form as last year. Rep. Overdorf has filed a special districts bill. Then we have all of these property tax proposals that have been filed in the House. The House is taking a very unique approach. They've decided to make a bill for 7 different property tax proposals and let the voters decide. It's not a very favored approach by the governor, who has come out and said so. Although the governor is soon to release his plan for property taxes, the Senate has not released any of their plans for property taxes yet. On the Senate side, we have seen the Democratic senators take the lead and start filing some property tax bills. There is no idea how all of this will play out. I think there is hope that it becomes just one bill so that voters are not overwhelmed when this measure goes on the ballot in the fall, that they have to decide between multiple ideas. Fred McLean filed land use development regulations. Again, he filed 2 of these bills last session. There's some components that are similar again this year. And then HB 217 and SB 218 land use regulations are tied into SB 180. So I will talk about that on the next slide about exactly what those 2 bills do. On the outlook and what we're always looking for as bills are filed, again, who knows, issues pop up that we were never prepared for. But APA Florida is very good about analyzing a bill when it does come out, and so we can take it forward to a representative or a senator and provide our perspective and our recommendations. SB 180 revision, we're watching for that. Impact fees, we know that that is something that was brought up on a House panel meeting in the first committee week, and it's something the governor's office is very interested in and looking at this year, is addressing or capping potential impact fees. Ag enclaves, community redevelopment agencies, live local, regional planning councils, always something to watch for. It seems to pop up in every agency bill every year. Regional transit authorities, and then this local government accountability report card is something that might come out of the Doge efforts from the CFO's office. Next slide, Patty. Lastly, I'm providing an SB 180 update. As Eddie mentioned earlier, in the presentation today, this is something that APA Florida has been looking at very closely since it passed. We actually wrote a veto letter expressing our concerns about sections 18 and section 28 that I know you were all very familiar with. And we are hearing that there are revisions in the works. It seems to be the Senate is driving those conversations about the revisions. Senator DeSigley has said it is something he's working on. Senator Boyd has told us that it is something he is working on. It also came up yesterday in a Manatee County local meeting, and they were all said again, especially on the Senate side, and Senator Leek has said it as well. They're looking at a narrow and tailor fixed SB 180. No one knows what that looks like yet. I think the House is in a little bit more of a wait and see mode to see kind of if anything starts moving in the courts, or is trying to see what they could do to narrow the impacts of section 18 and 28, potentially not an all-out revision. SB 217 and SB 218 that were filed by Representative Abbott and Senator Gates and Senator Trumbull, there's one thing all 3 of those members have in common, and they're from the Panhandle of Florida, and they decided to file a bill that will narrow the definition of an impacted local government. And so it will carve out the Panhandle counties, and it'll carve out, I believe, 3 down in South Florida. And their intent there is that these counties did not receive any federal aid and individual assistance, so they would be carved out of the definition of impacted local government. Unsure of where that goes this session. It is in, they're well intended and they're trying to help their local communities. Since it is a broad name, land use regulations, we'll watch those bills really closely to see if any amendments get on trying to address the other sections of the bill. And then lastly, I would just say that we are working with staff. The survey is really important, especially because committee staff and members have asked us, we know this bill is not liked. We know there are many concerns with this bill, but why? And so with the results we've gotten from from all of the local examples, it's really great to be able to say specifically, this in our comprehensive plan was deemed restrictive or burdensome, or we want to do this with a tree ordinance, but we can't because it's restrictive and burdensome. All of those are great because it's real feedback that they can see if they start to address narrowly tailoring what is restrictive or burdensome. The more examples we can provide them, the better. So please continue to fill out the survey, and we will continue to keep you updated on the conversations in Tallahassee. And Patty, that's all I have.
All right. Thank you, Anna. Great. And to Barry, Aaron, Michael, and Will for taking the time today to go through all these topics very, very extensively. We've got a few questions. I know, Patty, you got a few as well.
Yes.
How about this? I'll start off with some of the ones I've already received, and as you're able to jump in, I'm just going to go down the list that as we got them, and the first two are actually geared towards Mike's slides. So the first question I got was 384. What needs to be in the notice or the email that goes out? And also, if it's a written notice and not an email, does it have to be something that's certified or a certified mail, or how official does it need to be? Good question, really.
Yeah, and I'm looking to pull up the original language, but in brief, they don't even really touch upon it to that level of degree. And again, that's the specification is you can't just send it to a bulk email, like to then rely on somebody else to distribute it. It's got to go directly to the legislative folks. But there is nothing in there about requiring the certified mail, and even like the language on sending it out concurrently with the notice, kind of loosey-goosey there. And that's why I kind of say you build it in as a notice that kind of goes out regardless of state lands or not. You kind of cover yourself on that, but very, very loose.
All right, good to know. Thank you, Mike. Second question also for you, because it came in on 481. We heard about counties. Are municipalities allowed to have their own rules regarding this, the anchoring limitation areas, or can they, or do they have to defer to the counties within these within this legislation?
Okay, so that's a really good question about the general legislation. They didn't really touch upon it on the bills themselves, but I'm looking through like the relevant language on like establishing your own like mooring fields, and there it's referring to jurisdictions, not necessarily county anchoring limitations for the establishment of the mooring field. But they didn't really distinguish between municipality and county in this legislation, other than on the one that's dealing with the population level. It's just that 1.5 million population threshold to allow you to do it. So
Good to know. Thank you. I know from my own practice that Miami-Dade and Broward County both have their own county-specific rules. So if you're a municipality in those areas, I would encourage you to work with both your city attorney's office and the county attorney's office to kind of navigate this. If you're a planner with a request that come in from your commission or city manager's office. Let's see. Next one, Senate Bill 700. So that would be for Aaron and Barry. The first question that came in was about utilities, and going back to the slide on this, that there it utilities on land that was classified as agriculture. Question is, does it let's make sure I'm getting this right. Does it matter how it's classified? Is it classified on the basis of its existing use, is it future land use, or is it zoning? To what degree does this rule apply?
I should have said we're not going to take any questions on SB 700.
I believe, and I can double check real quick, that it has to be classified as agriculture as defined in statute, which is typically your property appraiser classification or some sort of agricultural tax exemption on the property. It's not necessarily going to be the, while that tends to kind of go hand in hand with zoning, as we all know, it's not always exactly correct. But I would say if you've got a property appraiser designation or if you've got some sort of agricultural exemption, that it would definitely apply.
Right. And definitely something to look for more into, right? Because we've seen it in other legislation that we covered in prior session. For example, with the Live Local Act, where the state went in and explicitly defined what it means to be commercial or industrial relative to this act. And so it's not about necessarily the land use designation on some of these, but rather the actual uses or permissible uses that we have. You could call it mixed use, but if all the uses are agricultural, then that's something to kind of further as a planner, or primarily used for agricultural.
Yeah, and I would add to that, so much of any of these preemptions for agricultural uses, whether that be the Right to Farm Act, SB 700 and its additions, the agritourism preemptions, all tie back to that ag exemption. It's amazing how it all hinges or pivots right upon that property appraiser's determination of whether or not you're a bona fide agricultural use. And be aware of that as local planners, and look for that when you're dealing with a piece of property that's looking to avail themselves of one of those preemptions. If they have that ag exemption, then typically that means the doors are wide open for them on those preemptions. And if they don't, well then they're still regulated under your local government regulations.
Yeah, and while we've been talking, I did just pull up the bill, and it does it defines agricultural designation by cross-reference to section 193.461 of the Florida statutes, which, as Barry just mentioned, is the property appraiser classification.
So I'm going to combine this with another question I got, and on another slide that you have on 211. Does that same apply for classification of agricultural in terms of uses in 211, or is there any difference?
So 211 cross-references the same statute. So it's again going to be the property appraiser definition.
Oh, good. Thank you.
Yeah.
Let's see. Patty, you want to go through your question while I try to make sense of this one I got?
Sure. This is also for Barry and Aaron. Does biomass processing include composting? You talked about liquefaction, but not composting.
Yeah, I didn't want to go through and Aaron, I think you had this perhaps on one of your slides, but there was a list actually of, I'm looking for it now. Yeah, no, it wasn't just liquefaction. It was a whole host of other methods by which you can create biomass, essentially.
Okay, everybody will get the slides so they can refer to that there.
Yeah, I was trying to see whether it was on the slide. That's annexed lands. Aaron, do you have that?
Are you talking about the list, the collection, storage, processing, distribution?
Yeah, that's it. Yeah. So yeah, what was that list again?
Collection, storage, processing, and distribution.
Yeah, and processing could mean quite a few things there. So I'd be real careful about. Again, I think I'd steer, as a local planner, I'd steer clear of it completely.
Let's see. All right.
I have
Another
a-
question for you both. Oh, Patty, go ahead.
No. If it's for them, go ahead, because this one's for Anna Grace.
All right, I got another question that came for them on the housing for legally verified agricultural workers. You mentioned that it said prohibit adoption of regulations that inhibit construction of housing. Since agricultural land has certain density designations, does that also override those density regulations?
Ooh. I would think
I'm trying to get to that one real quick here. Sorry.
if there
I
is
know that's
there
not an
are-
easy question to answer.
no. Okay. There are very, very detailed technical standards that this type of housing has to meet. Everything down to the percentage of climate controlled square footage, how far apart the structures are, what the setbacks have to look like, if they're adjacent to a residential use, what the buffer looks like, the type of planting that is used for buffering. If you want to do, a fence, it details what type of materials the fence can be. It talks about access driveways. I mean, I would think this is so comprehensive when it comes to the technical standards for this type of housing that I would hesitate to attempt to kind of override these provisions with a density, whether it's in zoning or a comp plan through a local government. I think that's probably preemptive.
Yeah, and I agree. I would not. I mean, don't ask those questions. Just don't try to find a loophole to involve yourself in this regulation. FDAX has made it abundantly clear that they wish to do so. Let them do so. It's that simple. I mean, I know we don't like the preemptions. They're they usurp our home rule, but at the same time, they do relieve you of regulating some pretty difficult situations, not the least of which is biomass creation and things like farm worker housing and a whole host of other things. And that's just in this bill.
Awesome.
I got a question that came in for you guys regarding HB 211. Does this mean that a local government can no longer regulate the cutting down of trees on agriculture classified properties since trees are a farm product?
Could we before? I don't think my take was that you couldn't regulate the removal of trees if it was
If it's a bona fide farm operation.
yeah, correct. Yeah.
So
Again,
it's got to not only be agriculturally designated property, it also has to be an activity of a bona fide farm operation.
correct.
So I think you probably, can't just, hey, I have ag property and I'm going to go cut, these trees because they're inconvenient to me. I think it has to be part of a bona fide agricultural operation in order for that to apply.
And well, it's an interesting question too, because then we have to consider what about the any invasive species, right, that happen to be on agricultural lands, or so they'll extend to that as well. I think that's where some of the question may also come into play.
And again, it's another unfortunate preemption for us there. It is used by developers who have an ag exemption on the property currently prior to development, who go out there and will clear the land ahead of any local government submittals. And that's unfortunate. But if you're out there trying to, again, find your way to regulate the removal of trees on ag land, that's going to be a real difficult chore for you. Saying that, hey, all the pines can go because they're it's silviculture, but that large live oak in the middle of the site should have stayed. I'd be real careful about wading into those waters.
I have a couple for Anna Grace.
Awesome. Thank you, Baron Aaron.
Guys.
Anna Grace, Carl's asking, are they going, for SB 180, are they going to reconsider the prohibition on the cumulative substantial regulation for flood damage? Sorry, I left.
Okay.
The cumulative substantial improvement regulations for flood damage. Sorry about that.
I would say the conversations that I have been in have been about addressing sections 28 and section 18 of SB 180. I'm not sure what other revisions they're looking at. I think they're trying to decide. That is something I can listen for and ask about, but it's not something I have directly learned.
Okay. Jason wants to know, are there any greater details on SB 208, which I'm not remembering from your slides what 208 was on?
Yes, that is the McLean bill on land use.
Okay.
It's related to infill residential development, which I believe we saw in one of McLean's bills last year that did not make it across the finish line. I will say I have a meeting with Representative McLean at the next committee week to actually learn more about this bill.
Okay. I don't know if this was, I think this might be for Mike or Will. I don't know what, Alex, if you want to help me clarify about carving out Braid or Miami-Dade or Broward counties because of tribal lands. Was that?
I don't think I had any on tribal lands for my stuff.
HB 2217 does not carve out Miami-Dade or Broward counties because of tribal lands removing exemptions.
My belief is the carve out in those is because those counties did not receive both federal aid and individual aid in the disaster declaration. That is why they're carved out.
Okay. Mm-hmm. Okay. Sorry, guys. I didn't know who that was for. It wasn't listed. Okay.
Yep.
Okay. Those are all the questions on my end.
I had one come in for Will. Will, on 1622, you mentioned ECL, the erosion control line. Can you opine or provide any sort of additional thought on if they need to be concerned about the CCCL on the as a result of this bill? For those that don't know, CCCL is the coastal construction control line, and it's that different than a erosion control line.
Okay, so if I understood your question, and I want to clarify, the erosion control line is what section 2 of HB 1622 is concerning with regards to those narrow counties, the 3 municipalities and less than 275,000. It does not address the coastal construction control line, which is a different line. And the erosion control line does not impact the coastal construction control line. So if you are in one of those designated areas or counties, again, Santa Rosa, Okaloosa, Walton, or Bay, and you are waiting on the DEP to establish an erosion control line, which Section 2 requires them to do, then you will get those updated maps. Now, whether that changes the CCCL line would be yet to be determined.
All right, thank you, Will. All right, any remaining questions from the audience? Patty.
None have come in.
I have one on, the EV. Let's see. We can go back to the EV slide. Which says vicinity. Barry and Aaron, are there specific distance that would be considered vicinity? How do we judge this?
That's a great question. And the answer is no. There's not really any clarification. The definition of EV charging station is pretty much exactly what I read, which is, the vicinity of the equipment, and specifically the associated parking. So
Right.
how far that extends is kind of an open question.
Right. And then another question was, my community had previously adopted an EV ordinance. Is that now also preempted, or has it been grandfathered in?
Yeah, if you have an existing EV ordinance, you're going to need to either remove it from the books or not. The problem is going to be, say the next application that comes in, if you attempt to enforce the ordinance as to that application, the statute will apply and you'll be preempted.
Mm-hmm. Yeah, and it's unfortunate because I know there's so many local governments that work really hard on preparing great EV ordinances, and they may have done so years ago, well ahead of any thought at the state level. But unfortunately, here we are with another preemption on exactly that thing. So I agree with Aaron. It's best probably to just repeal your ordinance and go with what's allowed in state statute.
No, thank you. Question for Anna Grace. I apologize if I had missed this, but it says HB 123 on special district. Can you provide us with more info on what it means by what it impacts on special districts for that?
Yes, this is again a pretty comprehensive special districts bill that we're still in the process of reviewing, and I know we have some subcommittees looking at it as well.
Mm-hmm.
I'm not fully prepared to answer that question.
Right, but we will.
But we will.
Yeah, but we will. So I think that's all the questions I had. Sent to me. If there's others, feel free to send them by email, and we'll do our best to forward it to the folks on the panel to try to get some answers. I do want to note that from AP Florida standpoint, as we get through these bills and we evaluate, we do send a regular legislative reader, and we will do so again this year. We're in the process of revamping the format to look at how it could be easy to read, and hopefully that will, as Anna Grace said, it's early on. So as we go through and analyze it and think through what these the words in the proposed legislation means, that'll actually come back and come out to you to all. And again, the reminder, the downloads are available on the material tab. And the slides will be sent after the webinar. So if you don't receive them, please contact Patty over at the Tallahassee office for APA Florida. The UCF AP Florida Senate Bill 180 survey will be at the top of the October 31st issue of our e-news and notes, as well as our APA Florida social media accounts. Thank you to all our panelists again for volunteering their time and putting together a great presentation. I learned a lot myself as a practicing a planner that I'm going to take back to some of my clients and some of my staff members after this. I hope you are too. And again, thank you for joining us for our final deep dive session for this legislative session. Have a wonderful day.